Good afternoon. My name is Julia Coakley, Chief Operating Officer, and on behalf of the MGAA, I'd like to welcome you to our market briefing today, IAF, Individual Accountability Framework Standards and Guidance, Central Bank, being delivered by Sunita Padda of Padda Consulting. Before I introduce Sunita, I'd just like to run through a few housekeeping points. Please ensure your microphone and your camera is off. And if you'd like to ask a question, please use the chat button at the bottom of your screen. Your question will be answered at the end of the presentation during the Q&A session. If we run out of time, questions will be answered post-event, which will be put directly to Sunita. This presentation is accredited for CPD hours if this is relevant to your ongoing professional development programme, and the briefing is recorded and will be uploaded by the end of next week into the MGAA YouTube website and into your dashboard. If you have a member user account, will be under events. You'll also be sent the presentation document along with a link to our survey, for which we really would urge you to provide your feedback. We do reiterate this, that your feedback is incredibly important to us at the MGAA team to ensure that we're delivering the best quality events for our members. So I'd like to introduce you to Sunita Padda, founder of Padda Consulting. Sunita has enjoyed over a decade of expertise in the insurance sector and recently has been instrumental in regulatory engagements with a prominent GI motor and home insurer. Holding distinguished senior roles at firms such as Howden Broking Group, XL Catlin and Lloyds, Sunita's pragmatic approach to compliance has always been rooted in a deep understanding of both business and regulatory landscapes. So Sunita, can I hand over to you?
Yeah, thank you for the introduction, Julia, and I'm going to crack on because we've got quite a lot to get through. I say that and then the slides won't work. Oh, there you go. So learning objectives for today, the individual accountability framework. So hopefully by the end of the session, you'll be able to describe where responsibility and decision making lie within your firm senior management. Outline and apply the firm's obligation to proactively certify the individuals carrying out certain specified functions are fit and proper. Summarise the common conduct standards and senior executive to understand the additional conduct standards, and summarise the key elements of the IAF and actions required. So those of you who will be familiar with the UK SMCR requirement may already start to see some of the common kind of the common ground in terms of this does to a degree replicate exactly what happened in the UK when SMCR was rolled out in 2018 to insurance firms and thereafter to intermediaries in 2019. I think I've got those dates right. If I haven't, apologies in advance. So the background. So the Central Bank of Ireland have decided to introduce the IAF framework to enhance accountability and governance across financial services sector. Again, similar to what the UK did. It stems from the Central Bank Reform Act. So there is a legal framework that sits behind it, again, similar to the UK. In this case, this is a response to the financial crisis. So the IAF has been developed in response to some lessons learned from the global financial crisis to make sure that there's greater individual accountability across the financial services firms. Prior to its implementation, there was a comprehensive consultation process, which you may have fed into, and it aligns with international standards. So similar frameworks in other jurisdictions, as I've already mentioned, like the UK Senior Managers and Certification regime. And there are other jurisdictions that have a very similar regime too. The key components of this framework include the Senior Executive Accountability Regime. And I'm saying this a bit slow because I do get a bit tongue-tied with some of the words if I try to say them too fast. So that's known as SEA, the Enhanced Fitness and Probity Standards, and the Conduct Standards. So they're all designed to clearly define and regulate the responsibilities of individuals in key roles. So there are three building blocks. So there is the minimum competency code of 2007. So ensure consumers receive minimum acceptable level of competence from regulated firms' representatives. So this is the introduction of qualifications meeting the minimum standards CPD completion required. So that's already there. The fitness and probity standards 2011. So this again is to guarantee key and customer facing personnel. They are control functions or pre-approved control functions, competent, honest, ethical, and financially sound. Now, some of you will have maybe experienced and still do in terms of those PCF role applications and the level of detail needed and the evidence needed to support that fitness and probity. And then now you have the individual accountability framework. So this is to make sure that the purpose of it is to establish personal accountability for certain roles or conduct aspects within firms. And the goal is to foster positive behaviour and a transparent culture. So that then strengthens the central bank's enforcement capabilities against both individuals and organisations. Again, not dissimilar to other jurisdictions, whether they're in Europe or worldwide. So the implementation timeline, so 29th of December, the activation of the conduct standards and the improved fitness and probity standards. Now, 1st of July 2024 is for those firms, targeted firms, who will be impacted by the SEER regulations. That does not apply to intermediaries or MGAs yet. The reason I say yet, because that is, we'll touch on that later on. And again, 1st of July 2025, the expansion of the SEER regulation to encompass non-executive directors, INEDs and NEDs at the targeted firms. So there is a phased approach there, but that said, there is still scope for the SEER framework to be broadened out to intermediaries and MGAs. So who's in scope? So you've got senior executive accountability regime. So this defines the accountabilities of senior executives, but noting that this is not applicable to insurance intermediaries and MGAs. Some of you may say, well, why is it in here? Well, I think it's really important to note that this will be touching firms at some point in the future. Conduct standards are enforced for all employees in regulated entities, and the improved fitness and probity standards, so emphasising the competence of individuals in pivotal roles. So the four pillars of the IAF, so you've got SEER, you've got the conduct standards, you've got enhancements to fitness and probity, and you've got reforms to simplify enforcement action against individuals. You can see there that it's a no to pillar 1, but pillar 2, 3 and 4 apply to MGAs. And that will be the focus of today's presentation. So under pillar 2, conduct standards, there are three sets of standards: common conduct standards, additional conduct standards, and business standards. And this part of the IAF applies to all regulated firms from the 29th of December 2023. So this applies to you now. Enhancements to fitness and probity introduces a requirement for firms to certify that all CF role holders comply with the fitness and probity standards. So there'll be a new annual return that will have to be filed as at the 31st of December 2024. This reminds firms of the obligation to complete due diligence on all CFs and PCFs. And this is all part of the IAF implementation as well. And then pillar 4, we have the Act includes a number of amendments to the conduct of administrative sanctions procedures which reflect learnings today. So that means that in terms of there are reforms to simplify enforcement action against individual. Again, not dissimilar to the UK. So what employees does IAF apply to? So this applies I think I won't read it all out because it is self-explanatory in this table, but I wanted to include the table so that it can be used as a reference point post the market briefing. And there you've got CF3, 4, 7, 8, and brings us on to the Common Conduct Standards. So the Common Conduct Standards, I mean, it's quite clear and basics, and it's intended for individuals in CF roles. It reflects good practice and standards, and most professionals already do this anyway. The specific standards include act with honesty and integrity, act with due skill, care and diligence, cooperate in good faith without delay with the central bank and any other relevant regulatory authorities, act in the best interest of customers and treat them fairly, operate in compliance with standards of market conduct and trading venue rules. Again, not dissimilar to conduct standards in other jurisdictions. So acting with honesty and integrity. PCF and CF roles are expected to hold this standard, upholding ethical standards through words, actions and beliefs. Individuals must be reliable and accountable, and they practice and promote transparency and honesty in all their interactions, following the firm's policies and completing obligation and accepting responsibilities for personal actions. I mean, we'll come into the presentation, further into the presentation about reasonable steps, about all the things that you need to think about how you implement this practically. So integrity contributes to an open, positive workplace, and that then feeds into culture to a degree as well. So what does IAF require for you to do to this common conduct standard? So acting with honesty and integrity. So operating without bias, avoiding, managing, disclosing conflicts of interest. This is stuff that you're doing already. So for example, obtaining comparison quotes before recommending a product provider, and explain why you have chosen a particular provider. Disclosing remuneration. So it's being transparent and open, not just internally, but with your customers. Don't pressurize customers. So insurance customers can make informed choices without any undue influence. Do not exploit a dominant market position. Provide comprehensive details of all the options. So statement of suitability and any recommendations to support that. Do not misuse or misappropriate assets or information in the of the financial service provider or its customers. And then report to management, again, whether it's through your whistleblowing, which is already within your firms, which should be embedded within your firms. So if you've got any suspected or actual legal contraventions or any breaches of standards by the firm, and then matters adversely affecting customers. And again, you know, this is not dissimilar to other jurisdictions. So behaviour is not consistent with acting with honesty and integrity. So not complying with your company policies, ignoring or breaching these policies and procedures, falsifying documentation or reports, intentionally destroying documents to avoid any legal or compliance obligations. And we have seen this happen. We have seen this. I think there have been fines in the past where firms have falsified documentation, misrepresenting information, and then misuse of resources. So whether you're improperly using company or client assets, or unauthorized access or disclosure of confidential information. So there's some good examples there. I'm sure there's lots more too. So acting with due skill, care and diligence. So competence in performance. So making sure that the abilities of the individual are consistent with the standards and what is expected for someone for a role that they are going to be performing. And if you do promote individuals to roles who don't necessarily have the skills and experience to perform that role. Be prepared for challenge from the CBI, because they will challenge and they may interview individuals as well. Your action should be measured against what is reasonably expected from someone with your qualifications, knowledge and experience. So if you are qualified to do something and you do have the competency and you do have the experience, then the expectation is that you should be able to perform that role. Acknowledgement that there are certain human limitations, so mistakes will happen. This regime is not here to say you are never allowed to make a mistake. Mistakes will happen. The key is always about the reasonable steps that you take, i.e., I did all my training, I've got evidence to say our conflicts were logged, but things happen and that's acknowledged and that is accepted. Understanding of business context, so the firm's activities that are key to you performing your role and responsibilities. Continuous development, so making sure that you stay abreast of any changes, educating yourself, making sure you go to the appropriate market briefings, follow-ups, and even through certain network committees and forums. And your commitment to your professional growth. So engage in those relevant training and qualifications that are required for you to continuously remain competent to perform your role. So to comply with the Common Conduct Standards as required by IAF, individuals must acquire the relevant knowledge. So get that deep understanding of the firm's business activities. So familiarise yourself with the strategy of the firm, any associated risks. Ensure you're clear about your expectation of your role and work towards any necessary qualifications. Understand the legal and reg framework. So knowledge of the legal and reg environment that's applicable to your particular firm. If you don't understand something, proactively seek some training on what the reg requirements are and get access to up-to-date compliance policies and procedures. Make sure you engage in that continuous learning. You know, I know that there's a huge shift in the regulatory landscape, not just in Ireland, but broader afield as well. So it's staying abreast. Nothing stays the same. So it's making sure that that continuous learning keeps up with the pace of change. Adhere to the firm's protocols. So there are policies, there are processes, there are procedures. They're there to ensure compliance within your firm. So making sure that you operate within the bounds of those systems and controls. And the implementation of policies, go beyond just reading and understanding policies, but by actively implementing them in your workplace practices. There may be things that you think, well, that doesn't make sense, or it's difficult to implement that. Those kind of things should be escalated to your compliance function. Don't work around it. If something doesn't work, then you need to escalate it. To align with IAF's expectations, you really must understand the business activities and risks, which we've already mentioned, and the risks associated with them. Ensure your professional qualifications remain current and relevant to your role. Stay informed on legal and reg frameworks and comply with the firm's systems and controls, all of which I've just mentioned. To meet the IAF standards for due skill, care and diligence, individuals are expected to prioritise harm prevention. So perform all their professional duties without causing harm to customers. And what does that sound like? Customer harm, consumer duty, and, you know, we can expect further changes within and further guidance from the CBI around that customer harm as well. But ultimately, that's the outcome that you should be looking to achieve, that you comply with company policies and you're making sure that there will be no customer harm. Communicate with clarity and accuracy, so making sure that customers understand the communication, they understand what they're buying, it's clear, it's accurate, it's current, it's not misleading. Making sure that you've got clear records and with the awareness that, you know, these can be requested through certain subject access requests by clients or regulators if they feel that there could be a systemic breach. So making sure that you keep an audit trail and you keep the records and there is an understanding. And make informed decisions. So approach all decision making, individually or collective, like making sure that you're fully informed and you've made a well-considered judgment. Seek guidance if you need to, and delegate decision-making authority when you're in doubt. So moving it up the chain of command as necessary. So escalating things to the senior execs, the board, as and when you feel it's appropriate or in line with your company policies and procedures. Oversee the delegation of responsibilities. So monitor the performance of tasks you have delegated. So if you are being held to account, you want to make sure that if part of what you are being held to account for that you have delegated, you need to ensure that that particular activity is carried out correctly and effectively. How do you measure that? Do you get MI? Do you get reports? Do you have one-to-ones? So you should be able to evidence that you're meeting your people management responsibilities. So in that, making sure that it's not just delegating responsibilities, but what do you get upstream to provide you with the assurance that that is being performed. And for board members, this means fulfilling fiduciary duties, so acting in good faith to promote the best interests of the companies, behaving honestly and responsibly, and exercise powers within the boundaries of the law. So demonstrating due skill, care, and diligence includes regularly attend a board, participate in those board meetings, diligently prepare for meetings by reviewing all the documents. So making sure that board meetings are set in advance, board papers are received in good time so that you are able to read them, and then you have sufficient questions to challenge the execs within the firm. Collective decision making. So making sure that there's informed and constructive discussions. These things are always minuted, and often these minutes and the board packs can be requested by the regulator at any point in time. Offer constructive challenges to management proposals wherever necessary. And then participate in consultation with stakeholders to get the diverse perspective and insights into whatever is being tabled. And then report diligently to the relevant bodies or committees, maintaining that transparency and accountability. So what could be seen as breaching this particular conduct rule? So the principle of acting with due skill, care and diligence could be breached if you're offering advice or guidance to customers when you're not qualified to do so, or you don't have the appropriate knowledge or experience. So when a new product is launched, you've got to make sure that you understand that product. And if that product goes through a product approval process, making sure that you're present. If you're involved in the sale of a product, you should be involved in that whole process, regardless of whether you're a manufacturer or a distributor. And don't pass yourself as an expert if you've got gaps in your knowledge. Participating or overlooking business actions which could lead to customer detriment or harm. Implementing practices or making decisions that maybe neglect the well-being of customers and they're more focused on, I don't know, let's say internal incentives of financial gain for individuals. Misrepresentation of risks and information. So not thoroughly communicating the risks associated with a particular product or service to a customer. So when you buy something, you want to know, well, that's good, but I really need to know what's covered and what's not, while I'm paying for it, versus how much, if in the event of a claim, what would my excess be? What other risks are associated with what I've just bought? And that needs to be clear to customers. And then providing information that is false, insufficient, or designed to mislead these products or services or professional credentials. So it's been making sure that you appropriately represent the risks and information associated with the product. And how can you best do that is to be involved in how that product is approved. 3, Sorry, I'm just doing a quick time check. Cooperating in good faith and without delay with the central bank and other regulators. So meeting this standard, making sure that there's a prompt and open response to regulatory requests. Nothing unusual there. This is what's expected already. Mandatory disclosure of information. So if the regulator requests information or there is a legal requirement to, making sure that you provide that information. Attend meetings and interviews as mandated by the CBI. Prepare for and engage with these interactions and making sure that, you know, if you are being asked to attend a particular interview or meeting by the CBI, making sure that you're fully prepped and engaging with your compliance and risk colleagues in that part of that process. Ensure that, you know, I can't stress this enough, you know, it's always going to be show me, prove it. So make sure that you've got appropriate information and records. Avoid any form of communication that could be seen as deceptive or fraudulent. Making sure that you maintain your records in line with your record keeping policy. Avoid any obstructive behaviour. So refrain from engaging in any conduct that could be seen as evasive, misleading, or intended to obstruct regulatory behaviours. Some of these are quite obvious, but nevertheless, this is a requirement. Behaviours that are not consistent with the principle of good faith or cooperation with the authorities. Dishonest, so it's quite the opposite, dishonest communication, non-compliance with the reporting protocols, obstruction of reporting, pressure on reporting parties, like maybe you're in a senior role and you've made a mistake and you're pressurizing your colleagues or others to alter or delay or leave information out. But that's not acting in good faith when cooperating with the authorities. Neglecting your engagement, so, you know, not attending an interview, not responding to requests from the CBI to attend a meeting or request. So all of these things are seen as behaviours not consistent with the principle. Number 4, acting in the best interest of customers and treating them fairly and professionally. So focusing on customer outcomes to ensure that firm activities align with what customers should expect when their best interests are prioritised. So again, some of this is reiterating what I've already said. Clear communication, responsiveness to issues. So if there's a complaint or there's an error from a customer, you have time-bound restrictions. You are required to respond within a certain time frame. So making sure you do that. Customer expectations and interests, you know, evaluate whether the whether the outcomes the customer actually experienced are in line with what they expected or what you expected. Transparent and informative interactions. So making sure that, you know, the products are simple, they're clear, the terms and conditions are clear. That will help reduce the number of complaints, making sure that all of this is communicated, especially if you're a wholesaler or a manufacturer, that this is distributed correctly through your distribution chain. Offer comprehensive information to allow customers to make the appropriate choices to suit their needs and objectives. Proactive problem resolution, so making sure there's clear procedures for acknowledging and rectifying any complaints or errors. As again, I said, there's policies and processes in place for that. Having a customer-centric approach, having the customer at the heart of everything you do. Ensuring the fair treatment, so things that you do not disadvantage or discriminate against certain customers. Provide equal access to information, support and opportunities for all your customers, and uphold ethical standards in all your customer dealings. Some of them are just stating the obvious, but nevertheless, you know, it's good to reiterate these and have these as a reference document. IAF sets forth clear expectations to ensure customers' best interests are the focal point of financial services. To comply, firms must ensure clear and accessible information, timelines of communication, appropriate advice and recommendation, and honest representation of services. Handling complaints. So promptly acknowledge the complaints. Follow up using your complaints handling procedure that aligns with the Consumer Protection Code. Seek to understand the issue. Get that feedback from customers. What went wrong? What can you improve? What can you make better? Any mistakes, pick those up swiftly. Communicate the errors and to the customers impacted as soon as possible. Follow your firm's errors handling procedure, which should be, again, consistent with the Consumer Protection Code. Ensure you fix it. So you've identified it's broken, fix it. Fair customer treatment. So making sure that avoid any actions or practices that could be considered unfair or prejudicial to customers. So always look to evaluate your business practice to ensure that there's fairness and in all of your customer interactions. Inadequate risk assessments. So engaging in recommending or advising on financial transactions without fully understanding and communicating the risks that are posed to that particular customer, failing to consider or disclose the potential downsides of a product or service. So you only tell them all the good things about it, but you don't tell them what they really need to know in order to make an informed decision. Providing advice or guidance on financial matters when you don't necessarily have the qualifications to do so, and advising customers in areas beyond your scope of knowledge. So prerequisites for PCFs and CFs to comply with market conduct standards and trading venue rules: compliance with the regulatory standards, awareness of the regulatory framework, understanding of the conduct risks, and adherence to specific codes and frameworks. You've got to make sure that any particular training that is specifically targeted for you as a PCF or a CF within your respective firms, you should attend those. You should evidence that you've attended those, because that will count as reasonable steps in the event that you would need that to. And they're the additional conduct standards. And there's the for the firms, for all the financial services firms, you've got different sections. So I'm just going to go through those one by one, but there are another additional 4 standards, but these are only applicable for individuals carrying out PCF and CF1. So those who may exercise significant influence. And again, it's like the equivalent in the UK is you've got the conduct rules that are applicable to all, and then you have certified persons, and then you have the SMF conduct rules that are the additional rules that apply to those individuals who exercise significant influence. So not dissimilar approach. So that the business of the firm is controlled effectively with honesty and integrity. So you've got to have, again, I'm not going to reiterate all the points that I've made already, but it's the comprehensive understanding of your business area that you look after, making sure that everything aligns with protecting consumer interest, making sure that you align with your board's strategic direction and risk appetites. For PCS with broader roles like CEO, making sure that this extends across the entire business spectrum, making sure that there's informed participation in meetings, i.e. decision-making, how those things are recorded, and how they are minuted is very important. The clarity of roles and responsibilities, making sure that you define and communicate responsibilities and accountabilities of all your staff clearly. Establish and understand proper reporting lines. So whilst SEER will require firms to have the equivalent of a kind of management responsibilities map, and you don't need to have that in place, it's always good to put something in place that you can pull out and say, right, this is what we've got in place that shows all the reporting lines and how our decision making is delegated and how that is sub-delegated across the firm. And making sure that you are engaged in all the critical discussions and assumptions across your firms. Making sure that the business of the firm is conducted in accordance with its obligation under the financial services regulation. So developing and maintaining the policies, making sure that these are updated. You have a responsibility that as and when the CBI is updating on different codes, or there's new regulation that's been coming out, that all your policies and procedures are updated, well defined, and actually compliance are providing you with the appropriate information to demonstrate that it's embedded. Compliance monitoring, making sure that there's ongoing monitoring mechanisms in place. What's the monitoring plan look like? What are your monitoring team looking at? How does that get reported back? Where are the gaps? What do you do about it? Staff awareness and understanding, making sure that there's the importance of that compliance training, making sure that everyone understands their role, their responsibilities, and any changes in regulation or legislation, and ensure the rationale behind the compliance practices is understood across the whole of the organisation. Regulation changes are not limited to compliance and risk professionals. This is important for all of your employees across the firm to understand them. So that's why it's important to have the those frequent, short, sharp training. Whatever your training is making sure that your training for your employees is sufficient to cover all of the changes that are coming through from the regulator. Any delegated tasks are assigned to an appropriate person. So you can't just delegate as a PCF or a CF1. You cannot just delegate to anyone. You've got to make sure that you're delegating to a person that holds appropriate knowledge and competency to start with. And what you need to be then doing is making sure that there's how that accountability is delegated. What is the criteria for delegating? What is that delegation process across your organisation? I.e., who can PCFs and CF1s delegate to? How is that managed and monitored? What training and support is given? Where's that documentation? What is the communication of that delegation? I.e., if you are delegating to me, do I really understand what my obligations are? And as a PCF or a CF1, what are you doing to follow up? I.e., regular one-to-ones, management information, reports, whatever it is, what is it as a PCF or CF1 that you will be receiving? And making sure that when something goes wrong, if a task is delegated to me, if something goes wrong, that I'm not putting it in my bottom drawer, I am escalating it and making sure that because whilst you've delegated a task to me and I may be responsible for it, you are accountable. So that's why that all becomes very important. Information of which the CBI would expect notice in respect of firms is disclosed promptly and appropriately. So regulated financial service providers must ensure the following is promptly and appropriately disclosed to the Central Bank of Ireland. So any offences or breaches, incidents involving the concealment or intentional destruction of any evidence, misinformation, investigation obstruction, legal proceedings, operational interference, decisions made by the regulated financial service provider stop providing certain financial services. So this is what the powers of the CBI, they can stop firms providing financial services and or products. Notification requirements, acknowledge the existing duty to inform the CBI of all of these matters as part of your regulatory compliance and transparency. So being open and honest with regulators has always been a requirement. This is just reinforcing that. I talked about reasonable steps. So the concept of reasonable steps is integral to the daily functions of a control function or a pre-approved control function holder. Engage in actions and control mechanism to comply with conduct standards. So making sure you comply, you know what your scope of your role is, making sure that you comply with all of the conduct rules that are applicable to you. Assess the impact of the actions and controls operated by others. So if you are delegating or if there are actions, both positively and negatively, impact your actions, you must make sure that you are making appropriate decisions and taking appropriate action, making sure that you effectively delegate and that you appropriately oversee. And then actively promoting a culture across the organisation that adheres to the conduct standards. Ensure that all key decisions, deliberation and challenges are documented and evidenced, because as I said, that show me, prove it piece is really important in reasonable steps. And the adequacy of the MI and reporting systems is, it gives you what you need. It's no point having MI coming upstream that is always reporting green. It's a bit like having a faulty dashboard on a car. Nothing's ever going to tell me that something's wrong. So I take a long journey and all of a sudden I break down in the middle because I've run out of fuel or I've run out of charge. And that's because I had a faulty dashboard. So challenging MI that is always green is a must as well. So reasonable steps, so understand your business area, identify your material risk, making sure your control environment is effective, and making sure that the whistleblowing protocols are in place. So familiarise yourself and all your direct reports with the organisation whistleblowing procedures. Ensure that people know what to do if they want to raise a concern. I know this is still a contentious piece across international regulation, actually, where individuals are reluctant to whistleblow, but that is there and you are expected to use it if you need to report something and if you fear that by going through the appropriate channels would have an adverse impact on your particular role. So, and implementing robust processes for identifying and rectifying issues or problems. So this is your risk and control framework within your organisation, your MI, your dashboards. Is it telling you what you need to know? Reasonable steps in the context of enforcement. So the central CBI can impose penalties, so not dissimilar to other areas for breaches of common and additional conduct standards. Demonstrating reasonable steps in compliance with the applicable standards can serve as a defence in case of enforcement action. So that's why that record keeping, that's why making sure that everything is documented is important, because that becomes your freedom card almost. Acknowledgement of human errors. If something goes wrong, put your hand up. It's a human error. This thing happened. This is how we identified it. Systems and controls working, tick. And this is what we're doing to fix it, updating and enhancing your controls, tick. And this is how we're going to communicate it, additional training to all employees, tick. So the human errors will occur. It's how you deal with them and how you notify the regulator that becomes really important, and the steps that you then take. The CBI will assess the reasonableness of actions based on what is expected from an individual in their position at the time of a particular incident. And then the concept of reasonable steps should be part of a CF role holder's everyday actions in managing their responsibilities. Understanding reasonable steps, central bank guidelines, so nature of the business, role functions and expected knowledge, actual knowledge and experience, systems oversight and problem remediation, and control or influence over issues. And central bank guidelines reference any specific guidelines published by the central bank related to these considerations above. So there's lots of publications. This isn't, the IAF is just bringing together a number of different publications. Fit and proper, so expanded scope for holding companies. So CFs and PCFs are now prescribed for various holding companies established in the state, including financial, mixed financial insurance and investment holding companies. So there's that annual certification requirement. So go through the fit and proper standards every year, making sure that you issue certificates of compliance for these PCF and CFs. And some of you may not know how to compile that certificate of compliance. We have created ones for the UK, so I'm pretty sure that those can be utilised or adapted to suit the CBI requirements. Written agreement and notification obligations. So PCFs are and CFs are required to formally agree in writing to comply with their F&P standards. They must promptly notify their firm or holding company if fit and proper standards are not met. So that annual certification of those individual, you need to do those financial checks, you need to do those criminal checks, because those are the kind of things that evidence the fitness and propriety. And while somebody might say, yes, I've got a degree and I've got a master's and I've got a PhD, again, it's going to fall down to show me, prove it. So, and I know the CBI are really strong on making sure they actually see the evidence of such qualifications. Enhancements to the F&P regime, so due diligence and certification. So due diligence, as I've said, is mandatory, must be completed before appointing someone in the role. So, you know, it can always be an individual is taking on a role subject to. So you may want to revisit your contracts of employment. What do they say when you make an offer to somebody who's going to come into a CF or a PCF role? Are there any changes to your contracts of employment that need to be made? And should you be on making an offer of employment, should it be subject to the individual passing all of these checks? So majority of the checks are conducted by the firm. Self-certification is acceptable only for specific aspects such as conflicts of interest and GARDA checks or convictions. Records of all due diligence must be kept for at least 6 years after the CF role has vacated. So somebody leaves, you are obliged to keep all of that information for up to 6 years. Why? Because if something happens that would have been under the watch of that individual who has just left, then those records become really important. Firms cannot allow a person to perform a role without a certificate of compliance. Certificate is given when the firm reasonably believes that the individual complies with the fit and proper standards. Firms must revoke the certificate if they are no longer reasonably satisfied. So if during the course of the year there's a criminal conviction, there's other issues that come to light, then that certificate must be revoked. And the components of the certificate of compliance, so these are the different components that should be part of your certificate of compliance. Certification requirements in the enhanced F&P regime, so it's prior to appointment, annual certification, certification for new CF roles, and then submission of certification data to the central bank. So annual PCF confirmation process, so that firms will be required to submit this confirmation of the completion of the certification process for each PCF role holder to the CBI annually, and then the annual confirmation for CF role holders as above. So what is required for, again, this table has been taken out of the guidance itself, but I've just redrafted it so that it aligns with the actual slides, and it's a bit bigger than the one in the actual guidance itself. So I won't go through this, but it allows you to see what is applicable for certification for the PCF role, CF1 and 2, and then CF3 to 11. We talked a little bit about the enforcement powers. So the CBI no longer needs to establish a breach of financial services legislation before taking any, by a firm, before taking action against an individual. So this is now focused against individuals and not the firm itself. Change allows for more direct and efficient enforcement against individual misconduct. The revised ASP enables the CBI to take direct action against individuals who breach a statutory duty of responsibility, whether for individual breaches or for participating in a breach committed by the firm. So if there is a broader breach, like let's say you were at a board or committee meeting and you made a decision, a collective decision, then and there was a particular issue associated with that, then that would fall to the collective individuals. Excuse me. And then The focus on the culture of compliance. So in sanctioning for breaches of the common or additional conduct standards, the CBI will consider the importance of promoting a culture of compliance within organisations. So how are you promoting compliance of the common and additional conduct standards across your respective firms? And then the CBI's enforcement approach will be proportionate and take into account of the extent of responsibility and the harm caused. So this goes through the certification conduct, again, the requirements, and then this just reiterates the learning objectives that I kicked off with at the beginning. And now I will stop sharing screen so I can see better to see if there are any questions.
Thanks, Anita. I wrote down a number of questions myself, but fortunately, rather than unfortunately, for every question I wrote down, you then subsequently answered. So I don't think there are any questions in the chat, and I did drop a message that if anybody did have questions, we should absolutely make the most of your expertise while we've got you. But as I say, I didn't have any questions. It was very thorough and some really great ideas and pointers to actually remind people of what they should be doing. There was one thing, and forgive me if whether you touched on it. I don't think you would have covered it necessarily in depth, but you mentioned about, adhering to the CBI's requirements, and if you need to present yourself and, that kind of, if it's not logged, it didn't happen kind of thing when you're recording and reporting. Would you expect members to receive a knock on the door from the CBI, or is that really more a case of if they are aware that there might be some failings, or what's your experience?
It could be a mixture of things. So there could be something going on in the market, and they might just be doing a little bit of like a thematic review, and they might be just, speaking to firms. You might be submitting an application for a new PCF or a CF, and it's not unusual for people to be called to interview. And especially, where we've got individuals maybe from the UK and they're then in Ireland, and it's more around, the mind and management of a firm being present within that jurisdiction. And also, again, it could be breaches. It could be that there could be a whistleblowing report that's gone in. You wouldn't know, this whistleblown could be somebody within a firm. It could be a disgruntled employee. You might not have done anything wrong, but then the CBI have an obligation to investigate. So it could be a multitude of things.
Of course, thank you for that. And then in terms of, you would hope that all of our members would have a really robust and thorough, reporting and auditing process to ensure that they're meeting all of these requirements. But if you were to give our delegates today, or again anybody watching this post event, kind of a if you like, a top three, doesn't have to just be three, but a top three of that's the thing, these are the things you really need to make sure that when you go away today you do first. Is that possible to say that? Because clearly all of it is incredibly important.
Yeah, so I think from an individual, I'll do it in two bits, right? So from an individual accountability perspective, these are the things that you are responsible for. Has your job description been updated to reflect those requirements?
Right.
Because often the job description, if you've been in a firm for a number of years, the job description gets left behind. That is your evidence as well. So if your role is changing, make sure your job description has been updated too. And then thirdly, on that, I would say it's about making sure that people have been trained and people understand the conduct rules. In the UK, I think this has been drummed into people for the past 4 or 5 years. So people do finally get it. And now we've got an additional conduct rule with the consumer duty. But I think it's understanding the conduct rules and what applies to you and what that means in practice. So that's an individual perspective. From a firm-wide perspective, if I was sat on a board, I would want to know the quality of my MI, and am I receiving sufficient MI that helps me discharge my responsibilities? and monitoring, am I proactively asking my second line and third line to go out there and provide me with gaps in my area so that I can proactively deal with issues? And thirdly, if there is an issue, if you have made a mistake or you've picked up an issue, notify the regulator. That's the easiest thing. It's how you do that that's important. Yeah.
Great advice. So the job spec, I think that's great advice because that should really be a relatively quick win. And the staff training again, excellent, and that kind of self-reporting. So we have got a question coming from the chat. Thank you. So it's thank you for the thorough presentation. Echo that. This is very similar to the FCA regime in the UK. Is there anything that should be highlighted as being different? It might be quite a broad question, but is there anything that you could kind of immediately pinpoint or?
I'm not, I think I've read the reason why I wanted to read out the detailed conduct rules and detailed rules, because whilst that detail may be different, the actual whole purpose of the regime is exactly the same. So if you're familiar with SMCR, if you follow that, but overlay it with the specific conduct rules and the enhanced conduct rules and the business standards that are specific to the CBI, you're going to be on track. Because that whole essence of what you need to do and why you're being asked to do it is exactly the same.
That's great. Great answer. Thank you, Sunita. I hope that answered the question there in the chat box. So I'm conscious we are now 3 minutes away from 2 o'clock. So really it leaves me to say, Sunita, as always, you really do present the best briefings to us. They're so thorough, so well thought out. And actually, if I might say, for a novice, very easy to understand, although they're content heavy, I think, as I say, very easy to understand. And the slides, as we kind of discussed before the briefing, they're wordy, but they just form a really supportive part of the presentation as opposed to just a backdrop to what you're presenting. So thank you for that. Padda Consulting. Sunita, I know you have various projects ongoing, so hopefully we'll have you back and talk about those sometime in the future, not too long. For our delegates, I would just say for our MGA members, we have our broker exchange on the 5th of March. I don't think we have any tables left if you were thinking of exhibiting. However, we would like to think that you'll come along as delegates to speak to brokers who attend. And we have a next gen speed mentoring event on the 1st of February in London. Again, do put forward your rising professionals to attend that. So thank you to our delegates. Thank you for taking the time. We've got some really lovely thank yous in the chat box there to wind up. So I hope you all have a really great day. The recording will be available within the week along with the presentation document following shortly. Don't forget to provide your feedback and have a great afternoon. Thank you very much.
Thanks, Julia. Thanks, everyone. And if anyone's got any questions, just email me via the MGAA. I'm more than happy to take any questions.
Thank you, Sunita.
Thank you. Bye.
Bye.